Welcome to the Deep Dive. Today we're plunging into a piece of U.S. legislation that has generated a tremendous amount of buzz and, frankly, quite a bit of confusion. We're talking about the One Big Beautiful Act, or the OBBB Act. This isn't just another bill, it's a massive, complex package aiming for sweeping changes across taxation, border security, welfare. And it carries significant and sometimes, surprising implications. Our mission today is really to cut through all that noise. We want to specifically unpack what this act means for you, our listener, as an Indian national. Whether you're living in the U.S. or perhaps in India with U.S.-linked financial interests, we're here to give you clear, actionable insights, things relevant to your situation.
Absolutely, and it's really essential we do that because, while the headlines might focus on the big numbers, the trillions in proposed spending or cuts the real story, the one that truly affects individuals, that lies in the nuances, especially for anyone with international ties. We'll show you how these seemingly disparate provisions are actually interconnected, how they could reshape your day-to-day life or maybe your financial planning starting very soon.
All right, so let's get to the heart of it. If someone's only seen the headlines, how would you describe the One Big Beautiful Act? What is this bill, essentially?
Well, officially it's designated H.R. 1, and it's a landmark legislative package championed by President Donald J. Trump. Its stated purpose is to implement, transformative changes across key federal domains, tax policy, border security, and welfare programs. It's really a broad re-envisioning of several core government functions.
And it certainly had quite a journey through Congress already. Fast-paced, it seems. What's the latest on its legislative timeline? And maybe more importantly for our listener, when might these provisions actually take effect?
Yeah, its journey has been swift and at times pretty contentious. The U.S. House passed it back on May 22nd, 2025. Then the Senate, after a very long kind of marathon vote-a-rama session, narrowly approved its version on July 1st. That needed Vice President J.D. Vance to cast the decisive tie-breaking vote. So now it returns to the House for final consideration. President Trump is pushing hard for rapid passage before July 4th. It's important, though, to remember that while a final vote seems imminent, the legislative text is still technically subject to potential adjustments. Small tweaks, maybe. But most provisions have specific effective dates set. For instance, that remittance tax we'll discuss. It applies to transfers made after December 31st, 2025. So beginning of 2026, really.
Okay, so the timeline is tight. Beyond those headlines, then, what are the core components? How do things like the proposed tax cuts, the spending reductions, border security measures, how do they fit together? And maybe which of these might have an indirect impact on our listeners' situation, even if it doesn't seem obvious at first.
Right. The OBBB has several big objectives, and they're definitely intertwined. First, it aims for what proponents call historic tax relief. It seeks to make permanent and even expand tax reforms from 2017. This includes things like 100% bonus depreciation for business investments, immediate expensing for domestic R&D, modifications to the limit on business net interest deductions. Now, these are pretty technical business tax things. They might not directly affect you as an individual unless you own a large U.S. business, but they represent a significant shift in U.S. corporate tax policy. The hope, proponents say, is stimulating economic activity here, which could, indirectly impact job markets and the economy overall. For individuals, there are new breaks, like no tax on tips and an increased standard deduction. Proponents consistently frame this as a benefit for American workers, farmers, and small businesses. Then there's a massive focus on border security and welfare reform. The bill puts substantial funding towards enhanced border security, increased deportation efforts, and notably, it introduces new fees for immigrants. We'll definitely dig into those later. At the same time, it mandates welfare reforms, things like work requirements for able-bodied adults without dependents, and stricter eligibility for federal programs like Medicaid and food stamps. A truly staggering detail here is the nearly $1 trillion in proposed cuts to Medicaid over 10 years. Projections suggest that could lead to maybe 11.8 million Americans losing healthcare coverage, and that would severely impact hospitals, potentially leading to reduced healthcare access for everyone.
Wow, $1 trillion for Medicaid. That's enormous.
It is. And then in terms of infrastructure and energy, there's about $12.5 billion for air traffic control modernization, plus strong support for traditional energy sources, oil, natural gas, nuclear power. This comes alongside discontinuing billions in tax credits for wind and solar energy. So that's a significant policy shift away from renewables.
It sounds like a lot of these broad changes, especially the tax cuts, are maybe being financed by those deep cuts to social safety net programs like Medicaid.
That's often how the budget math works out, yes.
So for our listener, how might these seemingly unrelated areas ripple through their lives, even indirectly?
Exactly. That's a great question. Consider this. Stricter welfare eligibility, even if it's not directly aimed at you as, say, an H-1B holder. It could affect family members who might join you in the U.S. later on certain visas. Their access to benefits could be impacted. If a family member might have otherwise qualified for programs like Medicaid or food stamps, their eligibility could be severely curtailed or eliminated. And that could place more financial responsibility back onto you, the sponsor or primary visa holder.
Ah, okay. So impacts on potential future family members. What else?
Well, there's also a less obvious but potentially quite impactful provision. It's the permanent end of the de minimis exemption for commercial shipments. This applies to shipments from all countries, effective July 2027. De minimis is basically that small value threshold, currently $800 for the U.S., below which goods can often be imported without duties or taxes. Ending it could significantly increase costs and administrative burdens for cross-border e-commerce. So this could potentially affect Indian exporters trying to sell goods into the U.S. market or U.S. importers bringing in Indian goods, and for you as a consumer. It might make your online shopping from abroad more expensive or perhaps delay deliveries due to more customs checks.
That's a powerful overview of the bill's broad reach. Really touches a lot of areas. But for many of our listeners, I think the real question is where the specific impacts lie for non-U.S. citizens and their international finances. What are the absolute must-know provisions there?
Absolutely. When we drill down to direct relevance for non-U.S. citizens and international finance, there are really three main areas you need to be acutely aware of. First, there's an excise tax on remittance transfers sending money abroad initiated by non-U.S. citizens. Second, significantly increased immigration application and renewal fees, a big cost factor. And third, and this one's potentially the most far-reaching in its indirect impact, it's Section 899. Section 899 is a retaliatory tax provision. It targets countries that the U.S. deems impose unfair foreign taxes. And that could impact foreign investment income coming from U.S. sources.
Okay, let's dive into that remittance tax first. This caused a lot of anxiety initially, right? There was talk of much higher rates. How will the current 1% remittance tax, as it stands in the latest Senate version, affect money transfers to India? Think about NRIs, green card holders, people on H-1B or other U.S. visas.
It's true. Initial concerns were very high. The proposed tax started way up at 5%, then it dropped to 3.5% in the House version. And now, in the latest Senate version, it's been reduced to 1%. That's a big drop. And crucially, it applies only to non-citizens. So that covers a broad range of Indian nationals living in the U.S., NRIs, Indian green card holders, folks on H-1B, L-1, or other U.S. work visas, and even Indian students here in the U.S., meaning even income from, say, part-time campus jobs could be subject if you remit at home. But here's the really crucial good news. And this, honestly, significantly mitigates the impact for most people. Transfers made from accounts held at U.S. banks and other financial institutions are explicitly excluded. Also, transfers via debit and credit cards issued in the U.S. are exempt.
Excluded and exempt. Okay, so just to be crystal clear, if you're using your U.S. Bank's app or maybe a wire transfer service linked to your bank or an online service like Zelle, Wise, Remitly, those are okay. No 1% tax.
That's correct. Based on the Senate text, those common digital methods are carved out. The direct financial burden is largely sidestepped for those types of transfers. That's a massive distinction, isn't it, compared to the early fears? The tax primarily applies now to transfers where the sender provides cash, a money order, a cashier's check, or similar physical instruments to a money transmitter.
That is a huge relief compared to the initial fears. Can you just reiterate why that distinction, digital versus physical, is so critical for our listeners?
It's critical because, let's face it, the vast majority of remittance transfers today happen digitally, through bank accounts, through cards, through online platforms. So while the 1% tax itself and the new compliance rules that come with it, which include increased monitoring, reporting transactions over $5,000 per day, stricter Know Your Customer, KYC, and ID checks, possibly even financial institutions revising Form W-9 to check citizenship status. While all that sets a precedent and maybe adds a bit of hassle, the broad exemptions for digital transfers mean the direct financial hit for most Indian remitters is far less severe than we first thought. It's unlikely to discourage most people from sending money home if they just stick to those digital channels. And remember, this tax applies to applicable transfers made after December 31st, 2025.
Okay, that's much clearer on the remittance front. Huge relief there for many. But beyond remittances, you mentioned substantial new immigration fees. What are these fees? How will they impact current or future immigration processes for Indian nationals? This sounds like a significant cost increase.
Yes. This is where the OBBB definitely introduces significant new financial hurdles. For example, there's a hefty $1,500 fee just to adjust status to lawful permanent resident, getting your green card. There's also a new $1,000 asylum application fee, plus a $100 annual fee while the application is pending. That's completely new. A $500 fee for temporary protected status, TPS. A $1,000 fee for individuals paroled into the U.S. And a $250 visa integrity fee, plus $30 for the Form I-94, the arrival departure record. Fees for certain waivers, like inadmissibility waivers, go up to $1,050. Motions to reopen or reconsider a case, $900.
Wow, those are substantial increases across the board. Does this bill offer any kind of relief or waiver for low-income individuals, or is it just a flat fee structure?
That's another really crucial point. Unfortunately, the bill states that fee waivers will generally not be granted. This is a significant departure from current practices for some immigration benefit categories where waivers are possible based on inability to pay. And what's particularly impactful, I think, is the major shift for Employment Authorization Document renewals, the EAD card. For certain categories like TPS, asylum applicants, humanitarian parolees, EAD renewals would be required every 6 months. And each time, it would incur a $550 fee.
Every 6 months. That's a huge change from current validity periods, which could be up to 5 years sometimes.
Exactly. It creates a continuous, substantial financial drain for people in those categories. Now, for H-1B visa renewals or transfers specifically, the bill doesn't seem to introduce new specific fees beyond these general immigration fee hikes that might apply to underlying petitions or related applications. But the overall landscape of much higher fees could still impact the process indirectly, maybe affecting employer willingness or calculations. Oh, and if you want expedited processing for tourist or non-immigrant visas, the bill allows for an additional $1,000 fee on top of the standard $185 application fee.
So putting it all together.
Yeah, if we connect this to the bigger picture, these cumulative fees and the more frequent renewals, especially for EADs in some cases, they will impose a substantial and ongoing financial strain on many Indian nationals. This could genuinely make the immigration process prohibitively expensive for some. And you have to wonder if it might deter highly skilled Indian professionals and students from choosing the U.S., or perhaps make it harder for them to stay here long term. It definitely raises barriers to maintaining or progressing their immigration status.
Okay, so higher costs for immigration processes. What about existing U.S. tax benefits? Will Indian citizens on H-1B or other temporary visas still be eligible for current U.S. tax benefits and credits? For instance, you mentioned Medicaid cuts. Does the bill's restriction on healthcare premium tax credits affect temporary workers? And do the new permanent tax cuts apply to them?
Right. This is another area with a direct and frankly significant financial hit for many temporary workers. Eligibility for the premium tax credit, that's the subsidy under the Affordable Care Act that helps people afford health insurance purchased on the marketplace. That eligibility is explicitly restricted under this bill. It's limited to U.S. citizens, lawful permanent residents, green card holders, and only certain other specific immigrant categories. The provision explicitly excludes most other lawful residents, and that includes H-1B visa holders and other temporary workers.
So if you're on an H-1B and maybe buying your own insurance through the marketplace, you lose that potential subsidy.
Correct. It means potentially substantially increased out-of-pocket health care expenses for many Indian professionals and their families in the U.S. They'll likely have to bear the full cost of their health insurance premiums without that federal assistance.
Okay, that's a major financial change. What about the general tax cuts, like the no tax on tips or the increased standard deduction? Do temporary residents benefit?
Regarding those general tax cuts, well, they're part of the broader tax reforms for businesses and individuals. For non-citizens who meet the criteria to be considered U.S. tax residents, which many H-1B holders are, these general provisions, like the increased standard deduction, would generally apply to them when they file their U.S. taxes. However, I'd say the primary new financial impacts for non-citizens specifically highlighted in this bill really come from that remittance tax framework and, more significantly, those increased immigration fees and the loss of the healthcare tax credit. The general cuts are less targeted.
And what about things like ESOPs or RSUs, employee stock options or restricted stock units? Many Indian tech workers in the U.S. have these. Any changes there?
Good question. For those holding ESOPs or RSUs while they are U.S. residents, the OBBB does not appear to introduce specific changes to how these are taxed by the U.S. at the point of vesting or sale. Generally, they're still taxed as ordinary income upon vesting, based on the value at that time. However, there's a connection back to the remittance tax. If proceeds from the sale of vested ESOPs or RSUs are then transferred out of the U.S. by a non-citizen, those funds would be subject to the 1% remittance tax unless the transfer happens via an exempt method, like from a U.S. bank account or using a U.S.-issued debit or credit card. As for Section 899, that retaliatory tax, it doesn't seem to explicitly alter the U.S. income tax treatment of this kind of compensation-related equity for individuals who are already U.S. tax residents.
Okay, that covers a lot of ground for those living and working in the U.S. Very helpful. Now let's shift our focus. What about Indian residents living back in India, but who have U.S.-linked financial interests? Maybe they invest in the India stock market, or perhaps they hold ESOPs from a former U.S. employer. How might the OBBB Act affect them, particularly that discriminatory foreign country, or DFC provision you mentioned earlier, Section 899?
Right. So first, let's talk about capital gains on U.S. stock sales for someone living in India. Generally, for non-resident aliens, capital gains from selling U.S. stocks are exempt from U.S. tax. There's an exception if they're physically present in the U.S. for 183 days or more in the year of sale, but for most residing in India, it's exempt. The OBBB, including Section 899, does not explicitly indicate any change to this treatment for portfolio capital gains from stock sales for individual Indian residents who are not U.S. tax residents. So if you're in India selling your U.S. stocks, this bill doesn't seem to directly impose a new U.S. capital gains tax on that sale itself.
Okay, so capital gains treatment likely unchanged. What about the remittance tax if they sell shares and bring the money back to India?
The remittance tax, remember, applies to non-citizens sending money from the U.S. An Indian resident living in India who sells U.S. shares through their brokerage and repatriates the proceeds back to their Indian bank account. They wouldn't typically be considered a non-citizen physically sending money from the U.S. in the way that the excise tax targets, so it would not directly apply to them either.
Okay, so the direct impact on capital gains from U.S. stock sales for Indian residents seems minimal, and the remittance tax doesn't seem to apply to repatriating those gains. But then there's Section 899, the discriminatory foreign country provision. This sounds like the big potential risk, the unknown factor.
It absolutely is. This is probably the most significant, although still developing, concern for Indian entities and individuals with U.S. income streams. Here's why. India has implemented an equalization levy that's widely seen as a form of digital services tax, or DST, and the OBBB text explicitly lists digital services taxes as an example of the kind of unfair foreign taxes that could trigger this provision.
Okay, so India's existing digital tax could put it on the U.S. Treasury's radar under this new law.
Right.
What happens if India is designated a DFC?
Right. If the U.S. Treasury Department officially designates India as a discriminatory foreign country, DFC, it could trigger increased U.S. tax rates on various types of U.S. source income flowing to Indian entities and individuals. These increases could be progressive, meaning they could start at maybe 5% and potentially rise up to 20% above the existing statutory U.S. tax rates. And this would likely apply to passive income streams like dividends and interest paid from U.S. sources to recipients in India.
Wow. So even with the DTAA, our double taxation avoidance agreement between the U.S. and India, which usually provides for lower withholding tax rates on dividends and interest, these new retaliatory taxes under Section 899 could potentially override those treaty benefits. That seems like a major shift in how international tax policy works.
It is potentially a major shift. And crucially, yes, the language suggests such increases under Section 899 could potentially override the reduced tax rates provided by the U.S.-India Double Taxation Avoidance Agreement, DTAA. This could lead to much more complex calculations and potentially significantly higher U.S. tax liabilities for Indian investors receiving dividends from U.S. companies, or for Indian businesses that have U.S. operations or earn certain types of U.S. source income. It would necessitate very careful and possibly revised tax planning. Imagine, like you said, planning your retirement income based on dividends from U.S. stocks, relying on the DTAA rates, and then suddenly facing a much higher U.S. withholding tax right at the source. It could really shrink your net income unexpectedly.
That really forces a reevaluation. What about those ESOPs, RSUs again, but for someone who worked in the U.S., got the stock, and is now returned to India?
Good point. So as we said, the OBBB doesn't seem to directly change the U.S. income tax treatment of the ESOPs or RSUs themselves at vesting or sale for someone who is now an Indian resident. Capital gains rules likely remain the same. However, if India were designated a DFC, any dividends paid on those U.S. company shares held by the person in India Those dividends could be subject to the increased U.S. withholding tax rates under Section 899, potentially overriding any DTA benefits for dividend income. So it affects the income stream from the shares, the dividends, not necessarily the capital gains from selling the shares. More broadly, this whole policy direction towards retaliatory taxation against unfair foreign taxes could also, indirectly just reduce the overall attractiveness of holding U.S. assets for Indian investors, potentially influencing capital flows in the longer run.
So, putting it all together, what does this really mean? The One Big Beautiful Act. It's certainly a mixed bag, isn't it? Particularly for the Indian diaspora and those with U.S. financial ties.
That's a very accurate way to put it, a real mixed bag. To summarize the key takeaways, while those initial big anxieties around the remittance tax have largely been eased by the generous exemptions for digital transfers, the new and significantly increased immigration fees will create a cumulative and, for some, quite heavy financial burden. And the explicit exclusion of H-1B visa holders and other temporary workers from the healthcare premium tax credits, that's a direct financial hit. It means potentially much higher out-of-pocket medical expenses for many.
Right. And for those back in India, while the direct impact on capital gains from selling U.S. stocks might be minimal, that Section 899 provision, the whole discriminatory foreign country designation risk, that could introduce entirely new, complex, and potentially higher U.S. tax liabilities on things like dividends from U.S. companies if India's digital services tax leads to that designation by the U.S. Treasury.
It sounds like this One Big Beautiful Act will certainly keep tax accountants and immigration lawyers very busy figuring out all the implications.
Indeed, they will be. The full ramifications, especially around Section 899 and its implementation, will continue to unfold over time. It really necessitates ongoing monitoring and probably some strategic financial and tax planning for all affected Indian groups, those in the U.S. and those in India with U.S. links. It's really a prime example of how legislative changes, even if they seem broad or focused domestically, can have very specific, very profound effects on international communities and individual financial situations. Absolutely. And for you, our listener, this deep dive really shows that being well-informed isn't just about catching the headlines. It's about understanding those crucial nuances, the details that affect you. And maybe this raises a bigger question for us all to think about. In our increasingly interconnected world, how will countries balance their domestic policy goals with these inevitable international implications? And what does that balancing act mean for the future of global talent, for capital flows in the years to come? Definitely something to mull over until our next deep dive.